That's right, everybody. We're back. This is attorney Jonathan Jacobs, and I want to talk to you today about relocation in a Florida child custody case. Of course, we call child custody time sharing. That is inconsequential for this argument. Whenever a new case law opinion is published, I am like a moth to a flame. I cannot wait to read it, digest it, find out how it applies to my other cases. This, of course, makes having any legal research software of the utmost importance. And here we go. Published from the 3rd District Court of Appeal in April, just about 35, 37 days ago in that vicinity, called NARA versus Acosta. In case any of you are case law junkies, 2026 Florida Appellate Lexus 2684 if you have a LexisNexis. If you do not have LexisNexis, this can be found in the Florida Weekly D730 or from Westlaw at 943-047. Anyway, the boring part of that is over. Let's get right to it. Apparently, this is really a fascinating story. A wife in 2024 filed a petition to dissolve her marriage and move back to Colombia with their child born in Miami 5 years previous to that. They had entered into 3 years before the divorce petition was filed some sort of a relocation agreement where the husband errantly agreed. Somehow, the Florida court decided that that 3-year-old child custody and relocation agreement at the trial court level passed the smell test, passed the muster, and allowed the wife to relocate. Not so fast. As we know from Florida Statute 6113-001, there are two methods by which a party wishing to relocate more than 50 miles away from their current address on file with a court or at the time of the last final judgment, that they may do so one by written agreement, as this case NARA versus Acosta presents, or two by filing a petition for relocation, having a temporary hearing, having a positive outcome at the temporary hearing, and then solidifying that if necessary at trial. In this case, that is not exactly what happened. And by the way, there was no transcript of anything from the trial court level, which is really a terrible mistake if you wish to appeal something. This is a tough one when clients or other people cannot afford to have a court reporter. It's a mistake not to. It's always best to attend any given hearing with a court reporter to make sure that every word stated is written down somewhere and also to keep everybody honest at these proceedings. There have been 1 or 2 times in my entire career where somebody said something truly offensive, truly mind-boggling, and there was no court reporter, unfortunately. Such as when one special husband said that his wife was nothing but a whoring, thieving piece of dog shit, and there was no court reporter at that hearing because the other side said they hired one, and they lied. Okay, here we go. The wife filed a motion to enforce the relocation agreement that was called just a settlement agreement. Unfortunately for the wife, and fortunately for the husband, although who knows about the minor child, which is really terrible to think about what's best for them, maybe not being upheld by the court because of procedural issues. That's the way these things go sometimes, and it's really an ugly reality that the relocation settlement agreement did not include a time-sharing plan. How in the world would any court of competent jurisdiction actually approve a relocation without a time-sharing plan, which also did not include anything about transportation arrangements? So there's no time-sharing plan for when husband may have his liberal visitation. There's nothing guaranteeing that the minor child ever returns to the United States, presumably to Dade County, and there's no guarantee that the dad can ever go see his child again in another country because there's nothing about transportation and there's nothing specifying when his specific time sharing is supposed to be. These are pretty fundamental foundational things that are included even in the basic of all basic parenting plans. The Florida Supreme Court approved parenting plan, which is free for self represented litigants. This relocation agreement which is supposed to be the most hyper technical and statutorily satisfied agreement, included nothing really that would allow the court to enforce it. This is, quite frankly, completely foolish, a bastardization of how the law is supposed to work. Here we go. While a party seeking relocation must present a legally sufficient petition, the parties may satisfy the statute by written relocation agreement, which must point in writing to one, that consent of all parties entitled to time sharing with that minor child is granted or given or agreed upon, and two, defines access or time sharing schedules, and three, describes related transportation arrangements. These things were not present. Simply stating that the husband would have liberal contact at the wife's sole discretion fails the relocation test. Utterly and totally fails. This was legally insufficient in every way that something could be legally insufficient. It never should have passed the general magistrate or trial court level. I'm not sure which. And it certainly was rightfully returned to the court and rightfully appealed by the husband. I do not believe that a relocation agreement that fails all things, and this failed all things, should stand. Sometimes something hyper technical might be damning to a case when it really shouldn't be. This is not one of those instances. This is just a total failure of the entire system all the way around, and it's unfortunate that it ever happened. Thanks, everyone.